Thank you, Robert. This is a really good question, and I think yesterday's news caused a lot of confusion. So let's break it down. What we heard yesterday was that the defense in the Karen Read trial filed motions to dismiss on 2 of the counts. That was the second-degree murder and the third count, which was leaving the scene. This is stemmed from some jurors. Now, apparently one juror has come directly to the defense. The other jurors have gone to other people who then have brought it to the defense. But they say they have as many as 3 jurors have said during their deliberations in that room, they unequivocally said 12-0 that she was not guilty of second-degree murder. And then they also agreed unanimously as well, 12-0, that she didn't do count 3, which was leaving the scene. Now, the second count was manslaughter, and there were different variations on the form of the different types of manslaughter. So I can see where, in order to say she's guilty of murder, you have to be convinced by ADA Lawley and those 68 witnesses, all of the prosecution witnesses that got up on the stand and gave all of their evidence, that Karen intentionally put her car in reverse and plowed into him out of anger. You have to believe that. And it sounds like when they went back into the jury room, the words that were described as that was off the table. If you don't think she intentionally hit him with the car, then it's hard to prove number 3, which would have been fleeing the scene, because I think both of those things kind of lock together. If you knew you hit him and you left him there, then that could have been the second-degree murder and the fleeing the scene. I feel like they go hand in hand. So not guilty for one probably easily relates to not guilty for the other. Now, the trick with the manslaughter charges is they provided a number of different variations on the jury form that the jury was to use that they would then hand into Aunt Bev at the end. Now, this might confuse it even more, which is not my intent, but let's look at this. This is the form for count 2. This was manslaughter while operating a motor vehicle under the influence, okay, or OVI, what they call it in Massachusetts. Now, this is the form they were provided, and you can see there's a couple of different options. What the defense was contesting from the very beginning is that there should have been not guilties under each certain section. Aunt Bev contested that this first one, saying not guilty, that means on everything. So not guilty of any manslaughter whatsoever. But the way this is broken down is there is a manslaughter while operating the vehicle. So the first one is sort of a voluntary. The second one is an involuntary, but you notice that second one, it's option number 3 here. It says guilty of lesser offense, involuntary manslaughter, but it mentions nothing about a car. And then the number 4, or the third choice, says that she's guilty of a lesser offense, which is kind of a vehicular homicide while intoxicated. So if I'm in the jury room, the one thing I will sit here and say very openly and very honestly is that Karen was drunk. She was operating a vehicle under the influence. So I don't think that's shocking, and I don't think that anybody disagrees with that. What the jury's responsible for is to determine her level of culpability in John's death, right? So an intentional manslaughter would mean that she was doing things that evening that she knew were harmful and could potentially lead to somebody else's death and did them anyway. In order for there to be voluntary manslaughter with the use of a vehicle, right? It's talking about motor vehicle under the influence. You still have to be convinced she hit him with the car. And if they're 12-0 saying it wasn't murder, then that's probably stemming from a large number of them saying she might not have hit him with the car. Now, maybe they're saying she hit him, but it was an accident. Okay, but that's then probably not voluntary manslaughter. That would be involuntary manslaughter or vehicular homicide. So we're down to the bottom 2 choices, right? You go all the way to the bottom of this form and you look at that bottom one. That's vehicular homicide. It's basically saying, in my interpretation, she was just so drunk that she didn't know what she was doing. Okay, fine. So maybe that's what they end up haggling over. But again, in order for me to sign up for that one, because it very specifically says vehicular homicide, you'd have to convince me, and you'd have to make sure that Lawley and those 68 witnesses all convinced you that he was actually hit by a car, when there's a lot of evidence that says he might not have been. So that brings us back to the number 3, which is this middle option down here where it just says involuntary manslaughter. It doesn't say anything about a vehicle. So if I'm in the jury room and I am somebody who feels that Karen Read did something wrong that night and deserves to be punished, I might consider this as an option, right? So that might have been what they were haggling over, because that one doesn't say vehicle. That just basically says there was her behavior that night could have led to his death without saying it was a vehicle. So that one's also kind of misworded in my opinion as well. So this was what they were hung up on. According to the jurors who were speaking, they said this started out, this count number 2 was a 6-6 split, equal. Then it went to an 8-4 split, with the 8s being guilty and 4 being non-guilty. In my opinion, I think the reason that the 4 were claiming to not guilty is because they weren't convinced that the vehicle was used to kill John. Now, a lot of people are saying, well, how do you know that Aunt Bev kept this hidden? I don't know that Aunt Bev kept this hidden, but that's why I asked, did she know and not say anything? Because the jurors, I would have assumed, someone correct me if I'm wrong, but I would have assumed when you hand in the letter to her to say, we are at a deadlock, I would think you would also turn on the jury forms. So she could see the form that says guilty, not guilty, whatever, she could see the form. She's under no requirement by Massachusetts state law. She's under no requirement to poll the jury or to announce in the courtroom what the verdicts are. We've all seen on TV where the jury foreman stands up and goes, on count 1, guilty, on count 2, not guilty. We see that, and that happens in a lot of cases, so they don't have the obligation to do that. So she is allowed to look at what they submitted to her, and she is under no obligation to poll the jury in the room and ask. And I don't know if legally she would have been required to say to either the defense or the prosecution, here's how the jury landed. I don't know what her legal responsibility is here. She didn't poll the jury, and she didn't announce on the record that they were not guilty on 2 of the charges and hung up on this 3rd charge. She just declared the entire thing a mistrial for all 3 charges. The defense team has filed motions to say, wait a minute, the jury is telling us that they were 12-0 on these 2 charges. She shouldn't be retried for that, and you can retry her for manslaughter only. So that's where it lands. There's a lot of conversation about what Bev should have or should not have done. I personally have thought she was leaning very heavily into the prosecution the entire time. In my opinion, she was slanted from the beginning. So I don't think that this was an oversight. I will say again, in my opinion, allegedly, I think she had the information and she exercised her legal right not to share it, even though maybe deep down she knew this one time it should have been shared. I don't know why she didn't. So there you have it. Hope that clears it up.